Good afternoon, friends. I'll come to the subject proper. Contempt of court, actually. But then it is slightly related with other aspects of contempt. Because contempt can be held by the court and it can also be held at the house of the legislatures. So now we will confine ourselves to contempt of court only, save and accept if there is a genuine need to refer to anything connecting with the contempt of the house. But by and large, we'll confine ourselves to contempt of court only. Okay? This word contempt originated from Greek, contemptuous, and thereafter it went to French, and finally it has come down to English, wherein it means having a sort of hatred or a disregard for any person or disrespect. Earlier, the word contempt it came down to us from Latin. As you all know, English law is a derivative of Latin law because it was the Romans Empire that had introduced all these things. And earlier, that is around 1,500 years or so, the church was invariably the administrator. So you have something known as the church, which is the administrator. It is also the executive. It is also the legislature, or you can call it, the judiciary. So the church was performing three jobs at a time, simultaneously. And the people in the church, they thought themselves to be greater than God. They could not digest, at least the Catholic Church could not digest any criticism against itself. The moment someone criticized whether the criticism was valid or not, there was spontaneous punishment. There was some sort of ego in the people who administrated because it was invariably kings of those times who ruled over the subjects, they ruled over the state in all its connotations. State could mean a regional state, state could mean a sovereign state, could mean many various other things. But by and large, they ruled over their kingdoms and the kingdoms expanded. It was mostly the British who expanded their empire to nearly half the globe. And this strange concept of contempt was originated from the fact that I am superior and you are inferior. I am the crown, you are the subject. You shall not do anything against me. You shall not question me. You shall not seek an account of my functioning. And whenever anyone spoke anything against the king, that person was invariably punished and punished severely. So much so, there were such things as cutting off the tongue. You won't believe it. If anybody uttered a word against the king of those times, the powers over there administrating the countries and administrating at that point in time, they went to the extent of cutting off the tongue of a person. So we come to this contempt, and gradually it has diluted now. Now the punishments are not so severe after after governments got elected through franchise and after there being a lot of sort of uh, outcry, and now there is certain amount of autonomy and certain amount of human rights and things like that, and punishments cannot be given at whims and fancies, but the punishments that have to be doled out are punishments that would appear to be rational and within the framework of law. So now we have contempt, where the contempt of court, where the punishment is maximum 6 months. Now, coming to contempt, there are two types of contempt with contempt of court. You will find the definition in section 2 A, B, C, 2, Roman 1, Roman 2, Roman 3 of the Contempt of Court Act 1971. If a person throws a slipper or something like that, or abuses a judge, or threatens a judge, that would amount to criminal contempt. So now what would amount to civil contempt? Non-compliance of an order or judgment, refusal to comply with something, that would amount to civil contempt. So contempt, as we see, has been gradually, the law has been evolving. There were three changes in the law of contempt of court. There was an old law, then there came to be a new law, and finally we had a law of 1971. But, I repeat, but pursuant to an uprising and a general sort of, agitation about people being charged with contempt, right, left, and center, the Indian Parliament has amended the Contempt of Court Act. I don't know whether the print has come out or not, but what was earlier truth was no defense in a contempt proceeding. Now, today, Parliament has agreed and amended the law that truth can be cited as a defense. Now, let us examine this. What do you mean by truth is not a defense? Earlier, the law was if you point out some fault of the judge, some shortcomings of the judge, some deficiency of knowledge of a judge, some error of the judge, or some deliberate undoings of a judge, wrongdoings of a judge, even though there was substance in your allegation, even though you had documentary evidence, oral evidence, and circumstantial evidence to consolidate your contention, yet it would amount to contempt. You were right in pointing out, yes, you were right in pointing out, but yet it would amount to contempt. Even pointing out genuine wrongs amounted to contempt because the ego of the judiciary had inflated to such an extent they just could not digest any criticism. Then came the time where some judges, out of maturity or magnanimity, began to look at it in a different context. And they were of the opinion that criticism should be welcome, more particularly constructive criticism. Therefore, the law gradually changed, and today quite a lot of judges are willing to accept criticism in respect of their working, but there are yet some sensitive judges that will charge you with contempt at the drop of a hat. The law has not been precisely defined, leaving it fluid. And no doubt there are definitions in the Contempt of Court Act, as I said, throwing off a slipper, shouting at a judge, intimidating a judge, ridiculing a judge, making gestures, obscene gestures, that would amount to contempt. Okay. The point is how do you segregate and how do you allege that a particular posture that you take or a particular face that you make or an utterance that you should say definitely amounts to contempt. There is no way of evaluating because one man's food is another man's poison. What is okay for me isn't okay for you. So we are left at the mercies of the interpretation of the Honorable Learned Judge. Now, here the question arises if we are left at the mercies of the Honorable Learned Judge, the question arises how can a judge sit in adjudication over a dispute wherein he is one party? This in itself amounts to the breach of the principles of natural justice. But there is an explanation for that. The statute itself confers the authority onto the judge because this is a very unique law. Unlike other laws, the law of contempt empowers a judge to sit and preside over a dispute wherein he himself is a party. Nowhere else in any other act will you find this. A judge can sit in contempt over a dispute wherein he is a party himself. Now, contempt again, looking at another context of it, contempt is a matter between the contemptor and the court, and third party doesn't have a locus standi as of right to intervene in that. Let us assume I've committed some wrong act of using foul language against the judge, and the judge is a very kind person, a nice person. He takes it in his stride. He is not aggrieved over it. A third party cannot complain. Any other party, whatever the locus standi, whether they are a respondent, complainant, whatever, they may be a petitioner, maybe respondent, maybe complainant, maybe accused, maybe applicant, maybe anything. They have no locus standi to initiate proceedings on contempt. Contempt is a matter between the court and the person committing the crime of contempt. You can at the most move an application requesting the court to initiate proceedings, but that is at the discretion of the court. Some Judges are kind and mild. Some judges are sensitive. That will depend on the Honorable Learning Presiding Officer at that point in time, whether he takes it as an offense, whether he takes it as a tribute, whether he takes it as an intellectual exercise or whatever. So when we are dealing with contempt, all young advocates and otherwise also other advocates should be very careful as to what you say and what you do. No doubt, if one apologizes, if there has been an error, slip of tongue, or in a moment where somebody is provoked, where heated arguments ensure over certain issues, and somebody may erroneously say something, that contempt can be purged if one tenders a genuine apology. Now, whether the apology is genuine or not, that again I cannot decide. One should tender an apology, preferably in writing, making out a complete unconditional apology. And the court may consider whether to purge that person of contempt or not. There are times when people have been charged with contempt and punished for just a few hours or until rising of the court. They are made to sit down in the court and the freedom is curtailed only for that day up to evening till the court adjourns. There are times when punishments is granted up to 6 months. There are times when the punishment is only fine. There are times when the punishment is imprisonment. Different kinds of punishments can be given, but not more than 6 months because 6 months is what is prescribed in the tables. Now, who all can commit contempt? Now, who is susceptible to this? By and large, mostly advocates because they are dealing with the court every day. Journalists are very prone to this because we are writing about court proceedings and otherwise other proceedings. And of course, the common man. But today, with the advent of social media, Facebook, Instagram, other Google platforms, and the WhatsApp, and so many other things, you have professional platforms like LinkedIn, etc. People are just speaking and writing, posting things left, right, and center without application of mind. Some people don't have the background of law, but they would like to express themselves under the misconception that they have freedom of speech. No doubt there is something known as freedom of speech, but there is limited freedom of speech. Doesn't mean it. Freedom of speech means you can even use abusive or expletive languages. Sort of freedom is curtailed and limited. The freedom is to the extent that you don't transcend other people's freedom. See, so people are going on with the social platforms and professional platforms, writing anything and everything and posting anything and everything. Actually, it is contemptuous, but courts up to now have not taken serious cognizance of this. Let us take. Let me take you to an example of contempt, practical example of contempt. As I told you, who can be hauled up for contempt? Advocates, public representatives also can be because sometimes they speak some things at speeches. But when they speak in the legislature, they have immunity because otherwise they would not have been able to perform their duties as people's representatives. There are times when they have to discuss something, discuss the conduct of some public officer, discuss the conduct of someone, discuss a particular policy, or discuss a particular happening, and that would attract contempt. But they have immunity to the extent that if it is done within the legislature and for a purpose of resolving some dispute or highlighting something, then it would not amount to contempt. For the simple reason that courts cannot call into question matters discussed in the floor of any legislature. But courts have been doing. Sometimes the court exceed the brief and the courts try to override and assert the authority. Case of Dr. Somnath Chatterjee. He was a senior counsel practicing at the Supreme Court, and he came to be elected as a Speaker of the Lok Sabha. I think it was in the year He came to be elected as the Speaker of the Lok Sabha. Yeah, I think it was 2004 to 2009, during that period. And he said something unpleasant about the Supreme Court judges. Notice was issued against him for contempt, because as you know, when a contempt takes place, they cannot summarily haul you up, try you, and convict you. You have to be given an adequate opportunity to defend yourself. And therefore, the first stage would be to issue show cause notice. The notice usually reads, you are called upon, you so and so are called upon to show cause as to why you should not be held for contempt by uttering so and so word or doing so and so act on so and so date at so and so time at so and so place. And if you fail to show, the court shall proceed in your absence or without your say. So you are called upon to explain your conduct. And if you do not have any plausible or good justifiable explanation, then you will be charged with contempt. And of course, you get your punishment, or whatever type of punishment is to be inflicted on you as per the schedules prescribed or as per the discretion of the presiding officer. But of course, not exceeding what is prescribed. It can be anything lower than that. So a notice was served upon him. This honorable gentleman, who was the Speaker of the Lok Sabha, he received the notice and failed to act on it. Judges of the Supreme Court were very angry with such behavior. They sent out summons. He received the summons and just threw it out and made a sort of, mockery out of it. The honorable judges of the Supreme Court were so annoyed with him, they drew out non-bailable warrants for his arrest, to be arrested and produced before the honorable Supreme Court. This gentleman, being a senior counsel himself, with many years of practice and nearly, I think, 8 Lok Sabhas elections he has won. 8 times winner of the MP's elections, a seasoned politician and occupying the chair, he refused to appear before the Supreme Court even with warrants. The warrants were to be executed by the police commissioner himself, who came to Parliament House but could not execute the warrant. Now, can anyone tell me why he was not arrested? I'd like to.
Yes, because without permission of the speaker, no member of parliament can be arrested.
No, he was the speaker himself.
Oh, yes.
Anybody would like to take a try?
He also has the powers for breach of privilege of parliament.
See, what happens is the speakers of the state assembly, speakers of parliament, and foreign dignitaries, ambassadors, the governor and the president cannot be arrested. So he has immunity, and the Honorable Supreme Court ought to have thought about that earlier before drawing out warrants. I don't want to say anything further, but when you seek to reprimand someone, you should see that it fits within the framework of law. Kings or heads of foreign states, diplomatic corps, and governor of any regional state, the president of the country, or the speaker of the Lok Sabha, and the state assemblies, they cannot be arrested. So they should have thought before drawing out the warrants. Anyway, that's a different story. Let me give you another example of contempt. Now, you all might have heard about one Mr. Khainar, Deputy Municipal Commissioner, who was a very controversial figure some 10 years ago, I think, 10 or 15
Mumbai.
years.
Yes, in Mumbai.
Yeah, he was very controversial figure. So he went about demolishing anything that was illegal was to be demolished, irrespective of whether it belonged to any MLA or corporator or anybody. He was functioning strictly according to the book, a very uprighteous man. But then politicians got annoyed with him and manipulated his dismissal from the municipal court. He was summarily dismissed. He moved, the court held that he should be and service benefits. What did I say? He should be reinstated with benefits. The Municipal Corporation of Greater Bombay refused to abide by that order. He went in appeal to the Honorable Supreme Court. The Supreme Court once again endorsed the order of this High Court, saying that he should be reinstated with all back wages and service benefits. In spite of the clear-cut order of the Honorable Supreme Court, the corporation never reinstated him and he went into oblivion. What happened to him thereafter, nobody knows. And nobody was held for contempt. Why? Because the legislature claims that the legislature is supreme and the Supreme Court claims that the Supreme Court is supreme. As to who is supreme, up to now it has not been deciphered. It's just hanging in animation. In certain cases, the Supreme Court claims that it is supreme. Why go that far? We can take another example. Take the example of Banu, some lady by the name of Banu who had sought maintenance, and the matter went right up to Supreme Court. Maintenance under Section 125 of the CRPC. That issue reached the Supreme Court, and the Supreme Court passed an order in her favor. In spite of the order in her favor, the accused in a trial court, her husband, never paid her that 125, the maintenance that was to be paid under Section 125 of the CRPC. In fact, the Honorable Parliament changed the law rather than comply with the law. I'm just pointing out these things to you to sort of stimulate your mind as to who is supreme and what is supreme. There's no proper definition at all. By and large, Supreme Court is supreme in most of the matters, but not in all matters, as we can see from these various instances that I have pointed out. So let's come to another example of contempt. If somebody, if a journalist or somebody, take a case of a journalist. If a journalist should write something, what factually transpired in the court, some jurists are of the opinion and some judges are of the opinion that fair criticism is permissible. Now, what would constitute fair criticism? If you write a factual story, what actually transpired, would that be fair criticism? If you add something to the story, for example, you add your own version or you add the opinion of various other advocates or some other learned people in the profession of law, would that amount to an offense? So there is no proper definition as up to today. This is a very vulnerable arena where you are left at the mercies of the judge, how he interprets it, and what are the factors that he takes into, what is his makeup, which society, which strata of society he has come from, whether he is a tolerant person, whether he is a broad-minded person. So if journalists write something, and even though it is factual, they can be hauled up. I'll give you an example where I have been charged. I have been charged with contempt on 2 occasions. One occasion, the matter went right up to the High Court, and I am proud to say I was convicted. Normally, nobody admits. It is a sort of shame to admit that you were convicted. But I wasn't convicted for any bad conduct or misconduct. I was convicted for refusing to apologize when my editor and other journalists, co-journalists, apologized. Now, the story is about, it is a factual thing that has come in the newspapers, etc. And it commenced over a police officer doing something wrong. There was an accident, car accident between Maruti and a Jeep, and it was an elevated road with fields on both sides. So with the impact of the crash, the Maruti went off the road and into the field, with its windscreen shattered and the driver hands and face cut with the glass splitters and things like that. The Jeep remained on the main road. The driver of the Jeep goes to the police station and manipulates the complaint by using some influence and things like that. He files a case against the Maruti driver. Panchnama is made, the driver of the Maruti is brought out from the vehicle, that was lying down there, taken to the hospital, entry is made at the hospital, Panchnama is made. One police officer going to the house of the Maruti driver and threatening his wife, demanding money, else I will put your husband behind bars. Now the lady got afraid and approached advocates. Most advocates were reluctant to take the case on the ground that no FIR was registered and therefore the question of anticipatory bail would not arise. How can you get anticipatory bail unless you convince the honorable court that there is a possibility of my being arrested? I apprehend arrest then and then only the court may consider. So in this case, there was no FIR at all. But surprisingly, there was a Panchnama and there was an entry at the hospital, government hospital, when any accused is admitted, obviously an entry is made. So we moved an application. One advocate with myself, we moved an application before the court. The court declined the application on the grounds that no FIR has been drawn out. You are come for anticipatory bail. You are not entitled to bail when there is no possibility of your being arrested. Then we called for the case diary and station diary and the Panchnama. Our contention was if a Panchnama has been made and if an entry has been made in the hospital that an accident has occurred, show cause, the police should show cause as to why they fail to register the FIR. When you are aware of an accident having occurred, you are duty bound as per 154 to make an entry first and then visit the site. You have not made the entry, 3 days have passed. So the judge was of the opinion, anyway, you have come for anticipatory bail, or if not anticipatory bail, then you want the regular bail. Both of these are being declined, and therefore I'm closing up the issue. Our contention was that is not the only subject matter before the court. Why is it that the court fails to probe that the police officer has committed an offense by not making an appropriate entry in the diary, in the station diary, about the accident? So, in any case, the Honorable Learned Magistrate closed up the case. The next day, I wrote in the paper, alleged police officer commits offense, magistrate fails to take action. The Honorable Magistrate was not agreed with me. He did not get angry with me. He was on good terms with me. But the bar got offended. The bar called a meeting and passed a resolution. That resolution was sent to the Honorable High Court, urging the High Court to consider contempt proceedings. And eventually contempt proceedings were initiated against me at the instance of the bar through the Advocate General of Maharashtra, who became the complainant and myself the accused. Now in this proceeding, summons was served of me and as well as the editor of my paper and the other people in the departments, the publisher, etc. They appeared before the court. We all appeared before the court. I have taken the stand that what was printed and published is what actually factually transpired. I have documents to substantiate my claim that this is what actually transpired. But the court was not of the opinion. The court says, your editor has apologized, your publisher has apologized. Why don't you apologize? I say, I cannot apologize I can apologize for an offense committed by me. If I was not instrumental in committing an offense, the question of apology would amount to something very funny. It will amount to sort of amount to making fun of the court, or that in itself will amount to contempt. How can one apologize for an act not done by them? So eventually the court says that we don't have time to hear you. I filed my affidavit in reply. I've given all my complete as to how the report was filed. And if at all the title was erroneous, in any case, the title was not given by me. Only the report was given by me. Normally, the titles are written by the sub-editors. Moreover, my report was in English and this appeared in Marathi. So the translation of it also could have resulted in possibly contemptuous writing, possibly. I use the word possibly contemptuous writing, but I don't know what was translated. They say the translation is offensive, the heading is offensive. the contents is not offensive, but the heading is offensive. I said the heading is offensive in any case. Headings are never given by the journalist. Journalists only write the report, and the heading is given by the subbing department. And since the subbing department has already apologized on affidavit and printed the apology in the newspaper, 5 copies of which are given to the Honorable Court as per directions on the last date, therefore the contempt does not survive, and the question of my apologizing doesn't arrive. But the judges were not of the opinion. They said, we don't care. We are not here. We don't have time to hear you. We are convicting you of contempt for 3 days simple imprisonment. Okay, I was convicted. I went in appeal against that. The appeal wasn't admitted, nor was it dismissed. Because in my appeal, I raised such issues such as how can a court not have time to hear you out? What was the documentary evidence against me on record to make out a case of contempt? Moreover, the Advocate General of Maharashtra was the complainant. Was he present at the site of offense when the contempt took place? The knowledge that he has is second-hand knowledge and not first-hand knowledge. In a criminal trial, original documents are to be produced and original version is to be produced. This is not a civil trial. This is a criminal trial. I raised many issues, and that contempt went into oblivion. I don't know what happened to it, but if one puts an RTI into all the police stations in India and all the jails rather, you won't find any entry of Edrich Miranda. But that was myself being escaped by the skin of my teeth. I don't suggest that you should take chances like that. If you commit contempt is a very delicate issue, and therefore we should be careful while dealing. There are times when the Honorable Supreme Court has said an advocate is not the mouthpiece of his client. Even if you are arguing on behalf of your client, if you are appearing on behalf of your client, everything that your client says, you need not follow it verbatim. It is your discretion as an educated person, as a professional. You have the background of law. What is to be said and what isn't to be said, you should know better. And don't say that the client said this, because you are not a mouthpiece of the client. The Honorable Supreme Court has said. So you should be careful of what you do, unlike in other professions. Same thing in the same thing you have in medicine. If a patient comes to a doctor, the patient can't tell the doctor, I want penicillin, I want amoxicillin, I want terramycin, I want chloramphenicol. What you want is immaterial. What you are to be given, the doctor decides. Same thing in the legal profession. What is to be done, the advocate will decide, because the advocate has studied law. You don't say what I want and what I don't want. That's wholly immaterial. So these are the dangers of contempt. Now look, let us go to say. Now we also find that one senior advocate from the Supreme Court recently was charged with contempt, which went on, and eventually he was released on a fine of ₹1 only. What do you make out of this? Anybody? Why impose a fine of ₹1 only? See, when there is no way out, it is a tug of war. On one side, you have the honorable learned judges who are not willing to bow down because of their designation and the post that they occupy, the respect that they command. It would become humiliating for them to admit that they have erred. At the same time, the Supreme Court advocate, senior advocate, and president of a bar, he also has his own ego. And if he is justified in saying something, then he would not like to tender an apology. So in such a tug of war, in order to save face, impose a fine of ₹1 on him and close up the issue. Or incarcerate him to the confines of the court for an hour or whatever and close up the issue. These are face-saving devices. You see, of late, a lot of such things have happened where egos are hurt, and or sometimes people try to just monopolize a particular situation. I have such a big following, or I have 10,000, 20,000 advocates supporting me, and therefore I can say anything or I can do anything. Sometimes some judges think, oh, I am a judge and no one can prosecute me because they'll need sanction under 197 CRPC, plus they will need sanction under the Judges Act. So I have double immunity, and therefore I'll go ahead and do anything I want, and nobody can do a thing about it. It's not like that. Both ways things can be done. But the legal profession, by and large, I scratch your back, you scratch mine. Nobody wants to antagonize anybody to the logical end. Everybody would like to be favorable with one another, amicable, to share bread together. So this is what we have in the legal profession. When the matters escalate too much, then they come together and iron it out. But that will depend on what kind of stand you have, what kind of backing you have, how long you can go on a strike. Everybody cannot afford it. Every common advocate cannot afford it. Even senior advocates cannot afford it. Unless you have many bar associations with you. Unless if you go on a strike and the strike is sustained, then there may be some negotiations to settle the issue. So contempt, as we see, is a very dangerous issue. Now, let me, I forgot one very important contempt proceeding. The errors that take place in the proceedings. Take the case of Honorable, what is his name? Kannan, Honorable Justice Kannan, who was from some South Indian court. He was a judge at a High Court judge at the South Indian court and was posted as a, if not mistaken, Chief Justice of some Calcutta court. And he was charged with contempt. He was charged with contempt. Being a High Court judge, he was charged with contempt. Now, what would be the procedure? To serve him a summons, serve him a notice, thereafter summons, and eventually warrant. So,
Participants, Edrich is asking a question. If anyone wants to answer, use the raise hand function. We'll unmute you all.
This judge has spoken something against his own brother judges, and therefore he was being charged with contempt. Now, here many questions arise from the academic point of view, from law point of view. They convicted him to, eventually he was convicted for 6 months of imprisonment. They convicted him on the ground that he was not available, he did not appear before the court, and therefore the court passed an order. Just for an academic exercise, if I may say, in a criminal trial, a person needs to be before the court when a judgment is passed. He has to be present voluntarily or arrested and produced before the court at the time of judgment. Without the party being present, the judgment cannot be passed. Save and except if that party is declared absconding, is not traceable. But in that case, it has to be published in newspapers and other means of publication that he is required to appear before this court, failing which the court shall proceed in his absence and pass any appropriate order as the court may deem fit. In this case, it was not done. Police was sent to arrest him. Sitting judge. It is alleged he fled from Calcutta and went to his native place where he was apprehended and incarcerated to the jail. Now, don't you think that there is something wrong over here? In the first place, did they seek sanction under 197 to proceed against a judge? Who gave them sanction? Without sanction, how did you proceed with the matter? He has sanction on two grounds. He has sanction under 197 CRPC 1973. He also needs sanction under the Judges Act. Okay, being the Judges Act, the judges may have granted. I'm not aware of the facts. But that 197 sanction ought to come from the President of India. If he belongs to the state, meaning if he's a magistrate or session judge, the sanction ought to come from the governor of the state. If he's a High Court judge and a Supreme Court judge, he belongs to the Union of India. He comes under the Union of India, and his sanction ought to be obtained from the President of India. So how do you arrest him and incarcerate him in execution of your order of contempt, judgment of contempt? These are things that you have to apply your mind and if you are supposed to argue your case, I would have argued on this ground. Firstly, he never appeared before the court. The court did not issue what you call the word proclamation. This word is known as a proclamation in a criminal trial, and erroneously or deliberately evades court proceedings. It is essential to put out a notice on the court, notice board of the court, and various other conspicuous places, including newspapers, that he is required to attend the proceedings on so and so date at so and so time, so and so case number, etc., for a charge under section so and so against him, failing which the court shall proceed in his absence. That wasn't done. So there are a number of shortcomings in that case. This is my personal opinion. I could possibly be wrong. I don't know. But let us set our minds in motion and try to understand as to how and why these things are done and how and why we can evade this or rectify this anomaly. I have many things to talk about. These are about contempt of the court. Sometimes contempt of the house is there, but contempt of the house is a different subject in itself. Nevertheless, I'll get to give you a slight thing connected. Contempt of the house is such that there is no definition of it, and it has not been defined in books as well because there is no law book. House proceedings are done according to the procedure laid down by the house. There is no act. You see, so contempt of the house can go on for punishment, can be any kind of punishment at the discretion of the speaker. Also, I want to invite your attention to magistrates and judges are also liable to contempt. They don't have blanket immunity. They have limited immunity. If you look at the section, if you look at a particular section, it makes it out very clearly. Only one inference can be drawn out regarding the interpretation of that. If you look at the section, the title of the section itself says Section 197 CRPC. When I'm saying the 197 CRPC, I mean the old CRPC because now the law has changed. Nevertheless, there's only the section. The section might have changed, but the law is the same. What earlier was 197 might become something else in this new acts that have three new criminal acts, three new acts that have come. So 197 starts with it shall be sanction is necessary to prosecute government servants and judges. It uses the word and judges. Now, had it not, doesn't a judge come under government servant? Why do they specifically say and judges? They could have said sanction to prosecute a government servant because a judge also is a government servant in one context. But they wanted to spell it out that even judges are liable to prosecution. Some magistrates and judges have been prosecuted in the past. It is not as if they can be prosecuted for contempt of their own court. They can be also prosecuted for their misconduct, even otherwise by speaking anything ill. Now, recently, something that is not befitting of their designation. Now, recently, some judge had said something about some, I don't know what, in some High Court judge of Allahabad in UP, he has said something about some community or something like that. Now, that also could be contempt could be drawn out against him. There's nothing prohibits the court from drawing out contempt against him. There are magistrates who have been held in contempt in Gujarat, in Bihar, and etc. I gave you the example of Justice Karnan also being a High Court judge. And one Supreme Court judge also was charged with contempt. Justice, now he is now the chairman of the Press Council, I think. I'm very bad with names. But he is the chairman of the Press Council of India. He was charged with contempt and I think he apologized and the apology was accepted. So this is in short. There are lots of intricacies that you can go into because there is no proper defense for contempt. Therefore, I'll rest my case with this to continue any other time if we have time. Yeah, come along with your questions. I hope I'm in a position to answer. I can't guarantee you I'll answer every query because I don't know everything under the sun. I'll try my best.
Edrich, a participant is asking, can the provisions be availed against a political party
Can
who
the
often criticize? Can the contempt of court provisions be availed against a political party who often criticize the judgment of the courts?
how can you do it against the party? You need to punish the person. Can you put the party in the jail? Has to be against a person. Criminal contempt, criminal. If it is civil contempt, sometimes civil contempt is a non-compliance. For example, if civil contempt, even corporates can be charged with civil contempt, not only individuals in civil contempt, because it is non-compliance. So if you do not comply with the order of the court or with the judgment of a court, you are committing contempt and you can be punished. As an individual, you can be punished in civil prison, or you could, or even as a corporate, you could be punished. But in a criminal matter, you cannot, because you have to put the person in jail. So how do you put a party in jail? Who's responsible? The person who has given who has said the thing, or the spokesperson of the party, or anybody who's taking the lead, or who has actually uttered the thing, or actually given a speech, or you know, does that
Okay.
justify this thing?
Yes, Edrich. The next question is there a very thin line between an opinion and contempt?
Thin, I think it is even thinner than a wafer line. Nobody can nobody can decide what happens when. It's like the climate of the Saudis. One time the sun and one time rain. In ours you have rain and in ours you have sun, bright sun. So you cannot say what happens when. Very delicate issue. Don't take the risk unless if you are a reformer and you want to reform the country. Then you may take the risk.
The next question is, sir, what is the basic line of distinction between a civil and a criminal contempt? You have covered this, Edrich, but in a nutshell, if you could repeat it again.
The civil contempt is if a court passes an order or a judgment and the person refuses to comply with it, that would amount to a civil contempt. But if you speak ill about the judge, or if you threaten the judge, or you ridicule the judge, try to make fun out of him, or humiliate him, or something, or do some act that will sabotage the cause of justice, that would amount to criminal contempt. For shouting at a judge or something like that, shouting or using expletives, or trying to make fun of him at a big gathering on a loudspeaker public address system. You say you tongue in cheek something. You say some where you don't refer to him directly by his name, but you are aiming at him, because there can be one and one conclusion only, that this statement was made to humiliate him. Then you can be held for contempt.
Yes, regarding this contempt, I think one must remember that while as say advocates, or we have to deal with filing some pleadings, etc. So one should remember that in legal criticism, we should criticize the judgment, don't criticize the judge. Because
Yeah, not
when the judge is criticized, then that is personalized matter, and then that may amount to contempt. So I think that should be remembered.
yeah,
And
that should.
secondly, yes, because when we criticize the judgment, even sometimes we say, so I think the language should be polite. Like in pleadings, we say that often we have to file appeals against the orders of lower court. So
Yeah,
at that
then
time, if we write that say learned judge, or learned my dear advocate, or my dear friend. So when we write learned, so after that we can say that whatever we want to say, like he didn't apply his mind, he didn't consider this evidence, that evidence. So, but we must write the learned lower court judge or learned district judge, like that. So the language of drafting must be polite, so that the pleadings are not held as offensive by the higher courts. Thank you.
yes, my friend, you are correct. The language should be polite, but it is not mandated that we should use the word learned or honorable.
Yes,
Without
there is
using
just
the
one.
word,
Yes, there is
without
just one
using the
observation.
word, without using the word honorable or learned, you yet can be polite by saying the judgment was in breach of law. The judgment was erroneous. The judgment was without application of mind. Uh,
Hmm.
Sometimes we use such words, but it is not mandated that you have to say the learned judge.
Yeah, or yes, or
He-
per incurium. So
But it
sometimes
is
we say
nice
it is
to
per
use the word
incurium.
learned. It is not
Yes.
mandated.
And even in, I think in, say, for journalists do not generally write this, say, Mr. Doctor, or like, say, learned, or say, honorable. These words are not used by journalists normally.
Yeah, it's not written.
Yes, yes.
Some
Thank
write, some don't.
Mhm.
In fact, most don't.
Yes, yes. Normally in press, generally they don't write this, say, salutations or the, say,
Yeah.
learned, honorable, and these words are not there.
This
Unless in case of the president or governor, like they write Mahamahima or Rashtrapati. Say,
this flowery language and the prosaic language is used only in the courts.
Yes, yes.
Journalese and legalese are two opposite,
Yes, 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 sir.
diametrically opposite.
Thank you, sir.
Okay. Edrich, there's one more question. If a judge is criticized not in the context of his judgment, but on his personal conduct, will it amount to contempt of court?
Now, as I told you earlier, this contempt is anything is contempt. If you cough is contempt. If you sneeze is contempt. Anything can be contempt, but that will depend on how you present your case. In my opinion, if I look into it from the point of view of a parliament has right to discuss under I think under rule 180, 138 or 183 something. I'm mixing it up now. But parliament has a right to discuss, and even state assembly has a right to discuss, because the constitution in one article of the constitution it says that no judge can be hauled up for no judge can be proceeded against. Parliament cannot proceed against any judge and things like that. But they are talking about, there's a rider to it. They are talking that no high court and supreme court judge can be hauled up. They is silent on magistrate and session court. So from that I have derived that, it is clearly, it becomes, in other words, it is saying that because the language uses no high court or supreme court judge can be called into question. Their conduct cannot be called in question and cannot be, become an issue for discussion. But it is silent on magistrate and session court. Why do you have to say specifically no high court and supreme court judge? Because obviously the courts below, you have no objection. What other inference can you draw out from that statement? And moreover, parliament cannot interfere with the working of the court, and court also cannot interfere with the working of parliament. There is courts cannot call into question any act of parliament. There is an article. I can't get it right away. Well, my memory is very bad. Yeah. There is an article that says that courts cannot call into question. So both cannot interfere in the working of each other. You see, but the conduct of a judge, or his professional conduct, if he's inefficient, if he's absent, if he's taking bribes, or if he's doing some mischievous thing, that can be discussed. Why not? Where is the bar? There is something known as a calling attention motion in Parliament. What is the calling attention motion meant for? It is meant to decide issues of public importance. Now, taking of a bribe, or deliberately being absent, or repeatedly being inefficient, passing wrong orders, or not passing orders for years together on a number of cases pending, this can always be discussed. Here we are not making allegations against personal allegations. There is no personal axe to grind. It is in the interest of the nation. It is interest of functioning of the judiciary, which is one branch of the government. But the nation functions, we have the legislature, the executive, and if if any one branch misfunctions, it can always be discussed in parliament. I've got rulings where matters sub judice before the Honorable Supreme Court of India have been discussed in parliament. Normally people say you cannot discuss the matter once it is sub judice. I've got rulings of Parliament House itself where it states, if you want, I'll circulate it to, I'll give it to you, you can circulate to the participants, where matters about some bank, what is that bank? Matters about Syndicate Bank, matters about Birla's company, and about Syndicate Bank. These two matters were discussed in Parliament, even though they were sub judice before the Honorable Supreme Court. So how does one account for this? I'll send it across to you. You can circulate among your participants, because there is a general misconception, to my to my mind, it appears. We are taught wrong. We are not told sometimes certain things. And we believe that the Supreme Court is supreme and no one can touch it. It is not like that. They are supreme in most of the matters. They are supreme in all the, most of the time the Supreme Court is supreme, but not necessarily that nobody can, discuss something about the malfunctioning of the Supreme Court.
Edith, next one more question. After the retirement of a judge, can his judgment be criticized, and will this amount to contempt?
There is no guarantee of anything. Judgments can be criticized, as we already discussed, whether he is sitting or whether he is retired. You can criticize the judgment, but you cannot criticize him by saying that he took money to give the judgment, or he's trying to favor some particular party because of his proximity to them or religion or something like that. We cannot make personal allegations against him. We can say the judgment was wrong from academic point of view. This was not added to, that was not applied, this was not taken into consideration, Evidence Act was not considered, the principle of natural justice was not considered, this was not considered, breach of constitutional law. And you have to point out which law, of course. But we cannot make a personal allegation against him. He is related to so and so, therefore he did this. He has taken money, therefore he has done this. This kind of allegation will invite contempt.
Okay. Edith, a participant has remarked that their assessment of this lecture is that no matter what the merit of the case, if a judge has a fragile ego, then you will be punished,
Yeah.
regardless of the merit.
There is no such thing as merit in contempt. It is a discretion of the court. If he pardons you, he pardons you. If he doesn't pardon you, it's a misfortune.
The last question, Edrich. What immunity do journalists enjoy, and can you give us some more of
Different type of people enjoy different immunity. Advocates would have some immunity. Advocates can get immunity under Section 126 of the Indian Evidence Act. I think 126, yeah, 126 of Indian Evidence Act, 1872. Then you can also get immunity by virtue of, Article 20, subclause 3, where accused cannot be compelled to, if an advocate has been charged with concealing something, uh, uh, you can get immunity under the Evidence Act. You can also get immunity by virtue of Article 20, subclause 3 of the Constitution. And you can get immunity because on another ground that the Bar Council of India rules mandates that it is the duty of an advocate, is one of the duties where advocates have many duties, 3 duties: duty towards the court, duty towards his brother advocates, and duty towards the client. So now, let us extend this concept, expand the concept of advocate, duty of an advocate. The duty of an advocate, it is the duty of an advocate to invite the kind attention of the honorable court if the court is doing something wrong, or if anyone else is doing something wrong. If the court is erring, if the court has not, if the court has erroneously failed to appreciate something, you can invite the attention of the court. So to that extent, it is your duty, and therefore you are performing your duty. So you should advance your argument on these lines. It was my duty. A duty has been cast upon me as per the Bar Council of India rules to invite the kind attention of the Honorable Court in the event of anything going wrong. It depends on your argument, what you make, if how you want to come out of your predicament. Once you are caught in the contempt, you can advance various types of arguments. Sometimes it may sustain, sometimes it may not. Now, journalists have immunity by virtue of the Press Council Act. You are not required to disclose, but that immunity is only that we are not required to disclose the source of information. But otherwise, we don't have the right to criticize the court on law point without giving a correlation or without pointing out which law has been breached and how it came to be breached and how it could have been avoided. So if we have the capacity to convince the honorable court on that point, then you can survive. But simply criticizing without there being any basis for the criticism will invite contempt.
Okay, Edrich. So, Edrich, we are done with the questions, and so can we end the session?
Yes, up to you.
Okay, thank you so much, Edrich, for your immense support to our platform, and thank you for such a wonderful session.
Thank you. I'm much obliged.
Okay, see you. Bye.